So, good afternoon, all of you. In the last class, we had introduced our topic and we had discussed the basic things that what is a constitution, then what is the subject matter that we are going to study in the coming classes, and then we had discussed in very brief the framing of the constitution. Now, you see, at the commencement of the constitution, at its commencement, the constitution had 395 articles divided into 22 parts and 8 schedules. That is the original constitution. And at present, it has nearly 485 articles divided into 22 parts, divided into 25 parts and 12 schedules. And 12 schedules. So, it was the original constitution, and at present we have written here 485 articles approximately. Now, basically, if we talk about the last article, it is 395. अभी भी 395 articles are there. Last number 395 है. But if you count the articles, it will come around 485 or even 490. Now, what is this? What are these parts? Then schedules, articles. देखो. First of all, when we talk about the parts, you see the parts are written like this: part 1, 2, 3, 4, 4A, 5, like this. And after the parts, we have the articles. Like this. So, the broader aspects are the parts, and then we have the articles. Some of the parts are multi-dimensional. They have got different dimensions. For example, if we talk about part 5 is the union. And within the union, we have the executive, legislature, and the judiciary. So, we have got chapters here. Chapter 1, the executive. And then we have the articles related to the president, the vice president, the council of ministers, the attorney general. Then chapter 2 is related to the parliament, that is the union legislature. Then the articles. So कहीं कहीं आप देखोगे कि we have got the parts and then we have got the chapters, then we have got the articles. Some of the parts, they are multi-dimensional. So there the chapter part, after the part we have the chapter and then we have the articles. Similarly, in part 6 also, part 6 deals with the state. Here also chapter number 1, executive, governor, the council of ministers, then advocate general, such chapter we can say topics are there. Then after that, chapter number 2, the state legislature. So first of all we have got the parts, then we have the articles, but somewhere we have got the parts, then the chapters and then the articles. So that is what we have written here, that originally there were 22 parts and today if we count then it is there 25 parts. ये 4A ये सबको मिला करके we have got 25 parts. Then coming to the articles, you say that whenever we talk about the articles, the last article is numbered as 395. अभी भी कॉन्स्टिट्यूशन का जो लास्ट आर्टिकल इट इज नंबर्ड एज 395. But why we say that we have approximately 485 articles or 490 articles? You see, the articles are written like this: 1, 2, 3, 4, 5. You will find such numbers. Then you will find certain numbers here like this. Now, these articles, they were there in the original constitution. So, articles are written like this: 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, like this. And these articles, where there is nothing, we can say no capital letters, it means they were there in the original constitution. Even article 19, original constitution. Now, if we talk about some articles they contain clauses. They contain clauses. Clauses can be written like this or like this. Like this. Article 19 clause 1. It can be written like this. Or our constitution makers have used this pattern. Articles, for some of the articles. Article 67 clause B. So if I say article 19 clause 1, we need to write like this. It is a part of article number 19. It is not a separate article. Then this article is a part of article number 67. It is not a separate article. Then some of the clauses have got sub clauses within them. बहुत बड़े बड़े articles भी हैं. So they have got sub clauses within them. Sub clauses are written like this. Article 19 clause 1 sub clause A. It is also a part of article 19. It is not a separate article. But wherever you will find capital A, capital B, capital C, means these articles were not there in the original constitution. They were added later on by amending the constitution. ये बाद में add on हुए. जहां जहां capital letters देखोगे, they were not there in the original constitution. ये बाद में एड ऑन हुए हैं, दे वर एडेड लेटर ऑन बाय एन अमेंडमेंट टू द कॉन्स्टिट्यूशन. So when you count the numbers like this and the capital letters, then it will be around 485 or 490 articles. It can be one or two more. Now, nowhere this question is asked that how many articles are there in the Constitution. Nowhere. Why? The simple reason is that it keeps on changing. For example, in the last session, suppose in the winter session, we had got 485 articles. Now in the next session of the parliament, suppose the constitution is amended, 2 articles are repealed. Repeal का मतलब होता है खत्म कर देना. So if 2 articles are repealed, obviously the articles will become lesser. Then simultaneously in the next session, suppose another amendment takes place, 3 or 4 articles are added, then it will be an addition to the constitution. So that is why in none of the examination it is asked that how many articles are there in the constitution, because it may change. आप देखो पहले जितने भी articles थे, the 106th amendment act was passed and articles were added in the constitution, that is for reservation for women in the Lok Sabha, article 330A was added. Then reservation for women in the legislative assembly, article 332A was added. तो 2 additional articles were added. तो इसलिए ये सब बढ़ते चेंज होता है, कभी घट भी सकता है, बढ़ भी सकता है. That is why such questions are never asked in the examination. अभी तो स्कूल के क्विज में भी नहीं पूछते हैं that how many articles are there in the constitution. हाँ, ये पूछ सकते हैं how many articles were there in the original constitution. Now, so this is the concept of state. So wherever I will say article 31A, 31B, you should write capital A, capital B. क्योंकि बच्चे पढ़ते तो हैं खूब पॉलिटी, लेकिन उनको यही सब समझ में नहीं आता है कैपिटल ए क्या है, कैपिटल बी क्या है. These things they need to understand in the initial classes only. पहले कॉन्स्टिट्यूशन पढ़ना तो सीखेंगे, then we will be going further. Then coming to the schedules, you see that some of the articles of the constitution, they need explanation, and if you start explaining them with the help of tables or any elaboration, then the coherency of the document will be lost. भाई इस आर्टिकल में और इस आर्टिकल में what is the difference, what is we can say the correlation. That is why we have got the schedules. For example, Article 1 of the Constitution says, India, that is Bharat, shall be union of states. Now, union of states means you will have to write the name of 28 states and the 8 union territories also that we have. So, after article number 1, you start writing the name of the states and then the union territories. The coherency of the document will be lost. You will not be able to correlate between article 1 and 2. आपका तो focus हो जाएगा on reading the name. So that is why the name of the states have been mentioned in schedule number 1. That if you are interested to see the name of the states, you should see schedule number 1. The name of the states and union territories have been given. Explanation of article number 1. Similarly, in Schedule 7 of the Constitution, there are the 3 lists. Now, you say that in one of the articles of the Constitution, it is mentioned that the center-state legislative relations are to be based on 3 lists. 3 lists. Legislative relations. That on what subjects the union government will make laws, on what subject the states will make laws, and in what subjects both will make laws. So, that is an article of the Constitution says that the legislative relations between the center and the states to be based on the 3 lists. उतना में काम हो गया, but we need to know, the Constitution need to elaborate also that what are the 3 lists. So a schedule was added in the Constitution, schedule number 7. And in schedule number 7, list 1, the union list, that on these subjects the union government can make laws. List 2, the state list, and list 3, the concurrent list. नहीं तो उसी आर्टिकल के नीचे if you start writing it, then it will be 4 to 5 pages, and the readers will not be able to correlate between this article and the next article. So that is why, तो बुक्स में भी आप नहीं देखते हो, लिखा रहता है सी अपेंडिक्स 1, जहां जहां टेबल्स एंड ये सब एक्सप्लेनेशन इज रिक्वायर्ड, it is written C appendix 1. So you need to see the appendix. But here we have got the schedules. Similarly, the oaths. We have the oaths of the ministers, oaths of the members of the parliament, oaths of the CAG, oaths of the judges of the Supreme Court and the High Courts. They have been mentioned in one of the schedules. And only one liner is mentioned, that a person who is appointed as the CAG has to take oath, and it is written as per schedule number 3. So the oaths have been mentioned there. There is explanation. So in the original constitution, we had 8 schedules, and now we have got 12 schedules. What are the different types of schedules? What are the subject matter of the schedule? We will be discussing later on also. तो उसमें आपको डिटेल में आई विल बी टेलिंग यू. ये तो इनिशियल क्लासेस हैं, यू नीड टू नो. सो दिस इज हाउ वी नीड टू प्रोसीड. तो जब मैं बोलूंगा आर्टिकल 19 क्लॉज 1, यू नीड टू राइट लाइक दिस. इफ आई से आर्टिकल 67 क्लॉज बी, यू नीड टू राइट लाइक दिस, स्मॉल b. When I will say article 31A, it will be capital A. So capital A, capital B means they are separate articles, and they were added by an amendment to the constitution. This is the carry forward of the last class, जो कि हमने लास्ट में कल पढ़ा था. अब now coming to another basic thing that we need to know before we proceed, it is the types of majority under the constitution. Kinds of majority under the Indian constitution. So when we say majority is the number required to pass a bill or a resolution in the houses of the legislature. That is majority. What is the number required? कितना number चाहिए? How many members should support it? That is the type of majority. Because in the newspaper you will be reading it that this majority was not there with the government, that is why the bill was not passed. So in the beginning only you need to know about the majorities. Simple majority. Simple majority is more than 50% of the members present and voting. Now suppose in the Lok Sabha we have a strength of 543 members. All the members are not present daily. Suppose on a particular day 500 members are present in the house, and if the voting takes place, it is not necessary that all the members should vote. ये जरूरी नहीं है कि सब लोग वोट देंगे. It is not necessary. So suppose during the voting 30 members abstain. 30 members abstain. Abstain means a person is present in the house but he is not taking part in the voting. That is abstain. So a member is present in the house but he is not taking part in the voting. So here present and voting will be 470, and the simple majority required here will be 470 divided by 2 plus 1. So even if a member is present in the house and he is not taking part in the voting, he will not be counted. उसका कोई काम नहीं है, he will not be counted. So this is simple majority. It is also known as working majority. It is also known as working majority. काम चलाओ बहुमत बोलते हैं इसको, working majority. Now, suppose if you have not understood it, I will make the things simpler for you. Suppose the strength of this class is that of 70 students, including our online students. And suppose if out of 70 of you, 65 of you are present in the class. Now, if I ask you a question that how many of you want a holiday tomorrow? It is a hypothetical question. There will be a class tomorrow. So, if I ask you that how many of you want a holiday tomorrow, 5 of you out of 65 will say, sir, we will not take part in such type of voting. If there will be class, we will come. Otherwise, we will not come. We'll take rest. So, 5 of you, what you did? You abstain. ऐसी छोटी छोटी बेसिक चीज आपको जाननी है. You need to know. Abstain. You are present in the class, but you did not take part in the voting. That is abstain. So, present and voting will be 60 divided by 2 plus 1. This is the simplest majority that is required under the Constitution of India. Now, here you can write as note, N-O-T-E. Wherever the Constitution is silent, wherever the Constitution is silent, on the type of majority required, wherever the Constitution is silent, on the type of majority required, comma, it is assumed that simple majority is required. It is assumed that simple majority is required. So, nowhere in the Constitution it will be mentioned that to pass this bill simple majority is required. Wherever it is mentioned that this bill has to be passed by the House or the resolution has to be passed by the House, means simple majority will be required. It is not that कि सर यहाँ तो लिखा हुआ नहीं है, it is not mentioned here. So which majority will be required? That is why, because for all other types of majority, the majority will be mentioned there. That what majority will be required. ये तो हुआ simple majority. Then बोलो बोलो. हाँ 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 हाँ, एनी वन, ऑब्वियसली कोई एब्सटेन करता है, किसी भी पार्टी का हो सकता है, कोई इशू नहीं इसमें क्या. नाउ कमिंग टू द नेक्स्ट टाइप ऑफ मेजॉरिटी, इट इज एब्सोल्यूट मेजॉरिटी. Absolute majority. Absolute majority is more than 50% of the total strength or membership of the house it is more than 50% of the total strength or membership of the house. It is fixed. In the Lok Sabha, it will be 543 divided by 2 plus 1, 272. Then in Delhi Legislative Assembly, it will be 70 divided by 2 plus 1. Then in the Rajasthan Legislative Assembly, it will be 200 divided by 2 plus 1. तो जिस हाउस में मेजॉरिटी चाहिए वहां पे डिवाइडेड बाय 2 plus 1, whether you are absent, present, it hardly matters. Then in Haryana Legislative Assembly, it will be 90 divided by 2 plus 1. These are the total strength or membership of the house. Then suppose in UP, the strength of the Legislative Assembly is 403. So 403 divided by 2 plus 1. Here, whether you are present, absent, it hardly matters. It is also known as majority of the whole house. Majority of the whole house. बोले पूरे सदन का बहुमत. Majority of the whole house. So now the question is where this majority will be required. It will be required in the lower house for the formation of the government. Now we are having the Lok Sabha elections. Why we are saying 272 seats in the Lok Sabha? People are saying it is a magic figure. What is this 272? Means it is more than 50% of the strength of the total strength of the Lok Sabha. The Lok Sabha's total strength is 543. So 543 divided by 2 plus 1, that is 272. If a political party or a pre-poll coalition gets 272 seats in the Lok Sabha, then we can say it will form the government. Its leader will be the Prime Minister. सिमिलरली स्टेट्स में भी यही होता है. सपोज यू सी इन राजस्थान, the strength of the legislative assembly is 200. The BJP has formed the government there. The BJP got more than 50% of 200 seats. उनको 100 सीट से ज्यादा वहां पे मिली. That is why they have formed the government there in Rajasthan. So basically, तो ये सब आइडिया भी होना चाहिए ना हम लोगों को. नहीं तो पूरे देश में कि अरे ये है, बट उनको पता ही नहीं है व्हाट इज दिस 272. So that is what we say, that it is the government of absolute majority, पूर्ण बहुमत की सरकार. And if none of the political party or the pre-poll coalition gets majority, then post-poll coalition takes place. चुनाव के बाद जो गठबंधन बोलते हैं, that takes place, post-poll coalition. So if 3 or 4 political parties, they combine together later on and they get 272 number, then obviously their leader will be appointed as the prime minister. So for the formation of the government, we require this absolute majority. समझ गए? This is the concept of absolute majority. No, earlier it was 545 because 2 members from the Anglo-Indian community, they were to be nominated. But now there is no nomination of the Anglo-Indian members in the Lok Sabha. That is why it is 543 now. Earlier it was 545, but now it is 543. So this is absolute majority, more than 50% of the total strength or membership of the House. Then coming to the third type of majority. It is effective majority. Effective majority is more than 50% of the effective strength or the then strength of the House. What we have written, more than 50% of the effective strength. Earlier it was of the total strength. Here we have written the effective strength or the then strength of the House. Effective or the then strength is equal to strength of the House minus the vacancies. Here vacancies will not be counted. For example, you see in the Rajya Sabha, suppose the strength is of 245 members, and out of this 245 members, suppose 2 members are dead, 3 members have resigned. These seats are vacant. Elections have not taken place for these 5 seats. These are the vacancies. These 5 seats are vacancies. So the effective strength will be 240. In absolute majority, we had taken this number 245, but in effective majority, this vacancies will not be counted. They will not be, the vacancies will not be counted. So here, the effective majority will be 240 divided by 2 plus 1. Why we write plus 1? Otherwise there will be tie, equality. That is why we can say plus 1. So here the vacancies will not be counted. बस इतना ही है. इसका ये मतलब नहीं है कि इसमें से जो एब्सेंट है उनको हम काउंट नहीं. They will also be counted. Even if out of 250 this effective strength 5 members are absent, it hardly matters. Otherwise it will become simple majority. So effective strength means minus the vacancies, this number, and we want to have a majority of 240. 240 divided by 2 plus 1. Now, where this majority is required? लिख लेना, this majority is required. ये लिख लिया ना आप लोगों ने? We have written it. This majority is required first in the Rajya Sabha for the passage of a resolution for the passage of a resolution for the removal of the Vice President of India. So here you see, we have not written the Parliament, we have written Rajya Sabha. So if the Vice President of India is to be removed, then the resolution is to be introduced only in the Rajya Sabha. It cannot be introduced in the Lok Sabha. And the Rajya Sabha has to pass the resolution by an effective majority. By an effective majority. And after that, the resolution has to be approved by the Lok Sabha. Approved by the Lok Sabha means approved by a simple majority. So, ये भी हम लोग detail में will be discussing it under the Vice President. But just as we are talking about the majority, so for the removal of the Vice President, effective majority will be required in the Rajya Sabha. Then secondly, in the concerned legislatures for the passage of resolution for the removal of their presiding officers. Now, who are the presiding officers? In case of the Lok Sabha and state legislative assemblies, the speakers, the speaker and deputy speaker. The speaker and deputy speaker. They are termed as the presiding officers. And in case of Rajya Sabha and legislative councils, it is the chairman and deputy chairman. They are known as presiding officers. So if the presiding officer of any legislative assembly or we can say the Lok Sabha or a legislative council is to be removed, then this majority will be required in that house. For example, if the speaker of the Kerala Legislative Assembly is to be removed, then this majority will be required in the Kerala Legislative Assembly. If the chairman of Karnataka Legislative Council is to be removed, then this majority will be required in the Karnataka Legislative Council. If the speaker or deputy speaker of Lok Sabha is to be removed, then this majority will be required where? In the Lok Sabha. Done? So, जिस house के presiding officer को you need to remove, there this majority will be required. Now the logic, the first point that we have written, the Vice President of India is the chairman of the Rajya Sabha. That is why the resolution for the removal of the Vice President is introduced only in the Rajya Sabha, and the Rajya Sabha has to pass it by an effective majority. That is the logic here, because he is the presiding officer of the Rajya Sabha. ये logic है. So in a layman's term, layman the common man's term, effective majority will be required in the concerned house for the removal of the presiding officer. This is the key word. So where in this year's prelims examination also this question is important. Why? Because the speaker of the Bihar Legislative Assembly was removed few months back when there was change of government there. No doubt the chief minister remained the same, but he had a coalition with RJD and the coalition failed, and that is why the council of ministers took oath again, but the speaker belonged to the Rashtriya Janata Dal. So the speaker was removed and this majority was required in the Bihar Legislative Assembly. So effective majority. So in the examination it will be the then strength, majority of the then strength. That should be your keyword here. So simple majority, the members who are present and voting, they are more than 50% will be counted. Then absolute majority, the total strength will be taken into consideration, and effective majority, the vacancies will not be taken into consideration. Absolute majority mein even the vacant seats were taken into consideration. 543 means 543, 245 means 245. Whether if some seats are vacant, it hardly matters, but here the vacant seats will not be counted. Now coming to the fourth type of majority, it is special majority. Under the Constitution of India, there are three types of special majority. First, not less than 2/3 of the members present and voting not less than two-thirds of the members present and voting. You see, it is mentioned not less than, means even two-thirds will also do. For example, in the Rajya Sabha, suppose we have a strength of 245 members and present and voting are 230. The majority required will be two-thirds of 230. Not less than means even two-thirds will also do. Not less than. In simple majority, it was more than 50%. That is why we had written +1. More than 50%. Here, not less than two-thirds. So, two-thirds of 230 will also do. This majority is required specifically at two places. That I will tell you when I will be discussing the parliament with you. क्योंकि आज तो अपनी second class ही है. There are many things which can be bouncers also. इसीलिए थोड़ा धीरे धीरे करके when we will reach the parliament till you will get the momentum of the class. थोड़ा बहुत हम लोग का wavelength will also match and you will be able to understand the things in a better way. तो उस दिन मैं आपको बताऊंगा and I will tell you कि I had told you in the second class only. So it is also a special majority, not less than two-thirds of the members present and voting. Then the second type of special majority. Under the second type of special majority, two conditions have to be fulfilled. First, it is the majority of the total strength or membership of the House that is the absolute majority and secondly not less than two-thirds of the members present and voting. It is not either or. Both the conditions have to be fulfilled. This condition as well as this condition. I will give you an illustration also. Suppose in the Lok Sabha, a bill has been introduced which requires this majority to be passed in the Lok Sabha. Now suppose in the Lok Sabha 450 members are present as well as voting. 450 members are present as well as voting. So here, when 450 members are present and voting in the Lok Sabha, the first requirement is 272. This is the first requirement. Why? Because in the Lok Sabha, 272 is the absolute majority. This is fixed. So this number has to be there. Means this many people must be supporting the bill which requires this majority. And then Second, not less than two-thirds of the members present and voting. Not less than two-thirds of the members present and voting. Two-thirds of 450 will be 300. Will be 300. So, 300 members must support the bill. Then only the bill will be passed. Why? Because 300 is two-thirds of 450 and it is also equal to or more than 272. Both the conditions have to be fulfilled here. Now suppose if out of 450 who are present and voting, 298 members, they vote in favor of the bill, if the bill will be passed or not. No. Why? Because 298, no doubt, is more than the absolute majority, but it is less than the two-thirds of the members present and voting. Both the conditions have to be fulfilled. Then coming to the flip side of it, when we say flip side of it, 400, here what will be the two-thirds of 400? करो calculate, CSET भी देना है, हाँ, you'll have to appear in the CSET examination also, हाँ, जल्दी जल्दी, क्योंकि मैं तो 10th के बाद मैथ्स पढ़ा भी नहीं, so 267, ठीक, 267. It is the two-thirds of 400. Now, suppose 270 members, they vote in favor of the bill which requires this majority. Then, if the bill will be passed or not? No, it will not be passed. Why? Because 270 may be two-thirds, it is two-thirds, but it is less than 272. That number has also to be there. Minimum 272 to we require. Along with it, that has to be equal to or more than this number. Both the conditions have to be fulfilled. Means it is a tougher majority. Not only this, another situation I will give you. Suppose 272 members, they are present as well as voting. Then, what will be the number required? 272 members are present and voting. A bill requires these two conditions. How many members should vote in favor of the bill? सोच के बोलो, you think? 272 members are present as well as voting. You require both these conditions. You require both these conditions. Are all should vote in favor of the bill. So even though it will be 100% of it, but it will be 272. So even if 272 members are present and voting, इसका two-thirds करोगे तो bill will never be passed. So all the 272 members who are present and voting, they should vote in favor of the bill. Then only such a bill will be passed. It is a bit tough one. क्यों? Minimum दे दिया, इतना होना ही होना है. Plus, it should not be less than two-thirds of the members present and voting. Now, where this majority is required? क्या होगा बेटा, कितना प्रेजेंट है? हाँ हाँ हाँ, तो अगर आप कितने प्रेजेंट है, कितना हमने बोला, 450 आर प्रेजेंट. आउट ऑफ दैट 421 आर प्रेजेंट एंड वोटिंग. वी विल बी काउंटिंग two-thirds of 421. Then coming to the next aspect, where this majority is required for. First, under Article 368, for the passage of a constitutional amendment bill in both houses of the parliament sitting separately, sitting separately. So in the Lok Sabha as well as in the Rajya Sabha, sittings, there is no joint sitting for this. So if the Lok Sabha and the Rajya Sabha sitting separately pass the bill, then only the constitution will be amended. So for the amendment of the constitution, this bill is required, sorry, this majority is required in both the houses of the parliament. That is why in the 2014 Lok Sabha, अभी तो 18th Lok Sabha का elections are taking place. In the 16th Lok Sabha, the BJP had, or the NDA had no majority in the Rajya Sabha. That is why it was very difficult on the part of the NDA. NDA का मतलब है National Democratic Alliance, the alliance which is being led by the Bharatiya Janata Party. So no doubt the NDA was in power because it had majority in the Lok Sabha, but in the Rajya Sabha it had no majority. That is why it was very difficult on the part of the government to get the constitutional amendments done in the 16th Lok Sabha. 17th Lok Sabha, it became easier for them because they got some more seats because they captured some of the states. Just like in UP, earlier they were not there. They came to power in UP and in some of the states. So they got the number of seats. And now, recently, we can say lastly, we had seen that the BJP is only 4 seats less than the majority in the Rajya Sabha. So with the help of the smaller parties, and if it comes to power in Lok Sabha, it can make amendments in the constitution without the support of any other political party. Earlier, the smaller political parties used to help the Bharatiya Janata Party's constitutional amendment bills, like the Biju Janata Dal, or we can say the YSR Congress. They were always used to help the Bharatiya Janata Party or the NDA. So, but abhi kya hai? Only 4 seats are left. That is, and they will get the majority in the Rajya Sabha. But we don't know about the Lok Sabha elections. Let the results come on, we can say come on 4th. So, this majority is required for the amendment of the constitution. Then, secondly, in both houses of the parliament, for the passage of resolution for the removal of the judges of the Supreme Court and High Courts the CAG, Comptroller and Auditor General of India, the Chief Election Commissioner, CEC, and the State Election Commissioners. The State Election Commissioners. So, you say that to remove these constitutional officers, the resolution has to be passed by both the houses of the parliament sitting separately. Then only the president can remove the judges of the Supreme Court and the High Courts, the CAG, the Chief Election Commissioner, and the State Election Commissioners. The State Election Commissioners are appointed in the respective state by the governors to conduct the local bodies elections, the panchayat elections, the municipality elections. They have nothing to do with the conduct of the Lok Sabha elections or the Vidhan Sabha elections. What they need to, they have to conduct only the election of the panchayats and the municipal bodies. They are appointed by the governor of the state, but they can be removed in the same manner as a judge of the Supreme Court or High Court is removed by the president. And then, thirdly, in a state legislative assembly, for the passage of a resolution requesting the parliament to create a legislative council for the state or to abolish an existing legislative council. Legislative councils are not there in all the states. How many of you belong to the states where we have got legislative councils? How many of you? Okay. You belong to which state? Uttar Pradesh. You? Tamil Nadu. Tamil Nadu don't have a bicameral legislature. They have got only one house, that is Legislative Assembly. You belong to which state? बिहार. आप? छत्तीसगढ़ में नहीं है लेजिस्लेटिव. बनाना है तो बोलो, मैं अभी बना देता हूं. नहीं. You belong to Andhra Pradesh. Yes. We have got a legislative council in Andhra Pradesh. हाँ. That is why I asked. And you belong to which state? You belong to Haryana. You belong to Madhya Pradesh. So you see, only in 6 of the states we have got the legislative councils. I'll be discussing these aspects in detail also in the coming classes. Now, here the third point that we have written, that how a legislative council is to be created. Basically, you say that for the creation or abolition of the legislative council in a state, the state legislative assembly will have to take the initiative. For example, suppose a legislative council is to be created in Madhya Pradesh. Then the Madhya Pradesh Legislative Assembly to pass a resolution by a special majority, the majority that we have written, requesting the parliament to create a legislative council for the state. So the initiative will be from the legislative assembly, and after that the final authority is the parliament. So the parliament by a simple majority can pass a bill and a legislative council can be created. The same is the process for the abolition of the legislative council. The initiative has to be from the legislative assembly of the concerned state, but that request by the legislative assembly has to be passed by this special majority. That is, the two conditions have to be fulfilled, but the final authority is the parliament. Before pandemic, Odisha and Gujarat, they had their legislative assemblies had passed the resolution for the creation of a legislative council, but it was not considered by the parliament. Then Andhra Pradesh Legislative Assembly had also passed a resolution requesting the parliament to abolish it, but the parliament had not passed a bill in this regard abhi tak. Kyun? Why? Because the final authority is the parliament. The final authority is the parliament. Only the request has to be from the legislative assembly. So here you see that under these three conditions, this special majority, the second type of special majority, can be used. So it is a tougher majority. Now coming to the third type of special majority. It is under Article 61. For the impeachment of the president. It is not less than 2/3 of the total strength or membership of the house. This number will be required in both the houses sitting separately. Legislative council. Basically, it completely depends on the parliament. It completely depends on the parliament. In Tamil Nadu, they had passed a resolution, but basically the parliament was in process also. But meanwhile, in Tamil Nadu, the government changed and the government withdrew the resolution. Because there is always rivalry. What the DMK will do, AIA DMK will undo it. So there is a rivalry there. So no doubt the governments have, we can say, the state legislatures have initiated, but the final authority is that of the state legislature. I just gave an example of Andhra Pradesh also. The Andhra Pradesh state legislature, they had also passed a resolution, but basically the parliament did not consider it. Now, this majority is fixed one. In the Lok Sabha, it will be 2/3 of 545. In the Rajya Sabha, it will be 2/3 of 543 and 2/3 of 245. It is the most difficult majority required under the Constitution of India. 2/3 of the total strength in the Lok Sabha, then after that 2/3 of the total strength of the Rajya Sabha. Both the houses sitting separately will have to pass it, and then only the president will be impeached. Now, generally the students ask a question that, sir, what is the difference between impeachment and removal? Because we have read even in the newspapers, even the Supreme Court during its observation also had used the term impeachment for the judges. Impeachment of the judges. Even in the newspapers also many a times we come across this expression, impeachment of the judges. Not only this, even in one of the question papers, the UPSC had mentioned impeachment of the judges. So if someone will ask you that what is the difference between an impeachment and removal, and why we use the word impeachment even for the judges of the Supreme Court, such type of questions may be asked to you in your interviews. Now, here you should say that, sir, constitutionally speaking, the word impeachment has been used only for the President of India. Then they will ask you, what is impeachment? You should say that, sir, impeachment is a special legislative process. It is not a normal legislative process. It is a special legislative process. And as soon as both the houses of the legislature pass the resolution, the concerned person is automatically impeached. There is no formal removal of that person. For example, in America, the president and the judges of the Supreme Court both are impeached. The process is the same. The resolution for the impeachment of the judge of the Supreme Court or the president of America is introduced in the House of Representatives, which is the lower house. After the House of Representatives will pass it, then after that it will be transmitted to the Senate, and the Senate is the main house, and in the Senate 2/3 majority is required for the passage of the resolution. As soon as the Senate passes the resolution for the impeachment of the president or a judge of the Supreme Court, automatic impeachment, the vice president will take over. In our country also, that is in India, if the Lok Sabha as well as the Rajya Sabha pass resolutions by this majority, sitting separately, immediately the president will be impeached. Means he will no longer be the president. So impeachment is a special legislative process. Now coming to removal. Removal is an executive order. And in case of India, the word impeachment has been used for the president only. We are under Article 61. And for the others, the word removal has been used. For example, when we talk about judges, I said that in loose terms, we have seen that the expression impeachment of the judges of the Supreme Court has also been used. अभी भी यूज होता है, इट इज इन यूज. सो यू शुड से दैट सर, a judge of the Supreme Court is removed by the president. Is removed by the president. But when upon the passage of a resolution by both houses of the parliament, upon the passage of resolution by both the houses of the parliament, by a majority of not less than 2/3 of the members present and voting, and by a majority of the whole house, and the ground here is also different, proved misbehavior or incapacity. So constitutionally, judge is removed by whom? The president. The president will remove a judge when after both the houses will pass the resolution for the removal. He cannot do it of his own. Then you will explain that, sir, the power that the parliament enjoys here, until and unless the parliament will not pass the resolution, the judge cannot be removed. So, sir, it is the important role which has been assigned to the parliament. That is why in that context, the word impeachment is used even for the judges of the Supreme Court as well as for the high courts. So it is in the context, but sir, constitutionally, the word impeachment has been used only for the president. And not only this, you see, the majority is different in case of impeachment and in case of removal. Then grounds are also different. Here in case of the president, the grounds for impeachment is the violation of the constitution. Then for the removal of the judges and the Supreme Court, it is proved misbehavior or incapacity. So only the context matches that until and unless the parliament will not pass the resolution, the president cannot remove the judge. That is why in loose terms, the expression impeachment is used even for the judges of the Supreme Court as well as the High Courts. But technically, the word impeachment has been mentioned only for the president. Done? So, these are the different type of majorities required under the Constitution of India. If you have got any doubt, you can feel free to ask me. Yes. Executive action. After you see in impeachment, what happens? Lok Sabha, Rajya Sabha, sitting separately, they will pass the resolution. One house will pass the resolution. It will be transmitted to the other house. The other house will also pass the resolution. And as soon as both the houses will pass the resolution, automatically the president stands impeached. Automatically. But in case of removal, after Lok Sabha and Rajya Sabha will pass the resolution will be sent to the president. That is, and both the houses will request the president to remove the judge. It will be a type of prayer. And then the president will formally remove a judge. No, it has to. It has to. That is why it is termed as impeachment in loose terms. Because if both the houses have passed the resolution, then president will have to remove it. Otherwise, it will be violation of the constitution and the president can be impeached also. Because both the houses of the parliament have passed the resolution. You will have to respect the mandate also. So, these are the different type of majorities under the Constitution of India. Now coming to the next aspect. So, ये हो गया majority. So, in the newspapers now if you read majority, the things may not be difficult for you. Now coming to the next topic that we need to start today, it is the salient features of the Indian Constitution. You see, there are two approaches of studying such type of topics. One is the one day examination approach. One day examination means SSC, or we can say the lower subordinate services examination, lengthiest constitution of the world. 2 lines are written in any of the general knowledge books. But here the UPSC approach is something different. In the UPSC examination, we'll have to follow our syllabus. In the prelims examination syllabus, we have seen that they have mentioned political system. It is my political system. Then in the syllabus of the main examination, it is comparison of the world constitution with the Indian constitution. So in the GS classes, it may not be feasible for us, and it is not necessary also to read the world constitutions. If you are reading political science as an optional paper, then, or you have done your graduation in political science, comparative government and politics is there, you'll have to study the different constitutions. But from the GS point of view, you need to have an idea in comparison with India. So, keeping in view the syllabus in mind, we need to approach this particular topic. Now, the first salient feature of the Indian Constitution is that it is a written constitution. No doubt Indian Constitution is a written constitution. Some of the constitutions of the world are unwritten. Now herein we will differentiate. So we know that we have a written constitution, but we also need to know about the unwritten constitution also. Now, why we say that the Indian constitution is a written constitution? Now, here you can write a written constitution. A written constitution is that constitution a written constitution is that constitution the provisions of which have been codified. The provisions of which have been codified. That is, systematically arranged in a single document On the other hand, when we talk about an unwritten constitution, you can write it here. An unwritten constitution does not mean that the provisions have not been written down, but they are not systematically arranged, but they are not systematically arranged in a document that is not codified, that is not codified. The examples here can be of a written constitution, the Indian constitution, US constitution, French constitution, Chinese constitution, etc. And unwritten constitution, the examples, the UK constitution, the constitution of New Zealand. This can be termed as the unwritten constitutions. Now, you can see that this particular document is the Constitution of America. One document can be termed as the Constitution of America or the Constitution of US. You can say that this document is the Constitution of France. This document is the Constitution of China. So one document can be termed as the Constitution of this country or that country. But in an unwritten constitution, it will not mean that the things have not been written down. They have been written down, but not in one document. Different statutes are there. Statutes means law books. That is the laws made by the parliament. So different statutes are there. For example, in United Kingdom, it is not that the things have not been written down. The things have been written down. But in one document, there is one law book, the parliamentary laws. Another booklet, the Judicial Act. Then one booklet, Rights of the People, Writ of Habeas Corpus. So in similar law books, एक law pass होता है, that is the law book is there. So you cannot exactly say that this document is the Constitution of United Kingdom. So the things have been written down, but here and there. Then secondly, in a written constitution, or we can say the written constitution is an enacted constitution. Is an enacted constitution. What is an enacted constitution? A group of people, they sat down together and then they wrote the constitution, they enacted the constitution, and then they said that okay, this is the Constitution of India. The Constituent Assembly enacted it. The American Constitution was enacted by a body called Philadelphia Convention. So the group of people, they were termed as Philadelphia Convention. So an enacted constitution, wrote the constitution, this is the constitution of this country. On the other hand, an unwritten constitution is an evolved constitution. It is an evolved constitution, gradual evolution. Means it is not that a group of people, they sat down together and 1 hour, 1 year, 2 years they took and they wrote the constitution. For example, you can write it. The English constitution or the British constitution started evolving. The British constitution started evolving since 1215 AD, that is the time of Magna Carta. That is the time of Magna Carta. Magna Carta was the decree of the king, and in 1215 AD, the British king, he issued a declaration, and he resolved to do something for the people. I will treat everyone equally, then no one will be punished or hurt. So certain words, certain aspects which were there in 1215 AD, those aspects are present in the British system even today. The new laws are made, the earlier laws cease to exist. No doubt, every constitution it evolves around, we can say, through the time, because change is the only unchanging reality of this world. But in case of India, how the constitution will be changed, it is mentioned in the constitution itself, which is not there in Great Britain, because no constituent assembly was there. Gradual evolution, that okay, today this law is made, tomorrow that law will be made. Gradual evolution with the times and circumstances. And then the most important aspect, in a written constitution, there is supremacy of the constitution. Whereas in an unwritten constitution, there is parliamentary supremacy. There is parliamentary supremacy. So wherever the constitution is a written one, the constitution will be supreme. Why? You can write a note here. All the three organs of the government owe their origin and derive their authorities from the constitution. So in a country, if someone will ask you that in democracy, who is supreme? So in democracy, the people will be supreme. But when we talk about the organs of the government, then none of the organs of the government will be supreme. The constitution will be supreme. No doubt in India, there is perception among certain sections or people that here judiciary is supreme, because the judiciary, especially the higher judiciary, has the power to review the laws made by the legislature as well as a decision of the executive. That is why people feel that the judiciary is supreme. But who has given the judiciary this power? The constitution has given this power. So the constitution is supreme. Such type of questions can be asked in reasoning assertion. That in India, there is supremacy of the constitution, and all the three organs of the government owe their origin and derive their authority from the constitution. Both A and R are correct, and R is the correct explanation of A. And in the last class also, we had discussed that the objective of the constitution is to provide for a limited government, to restrict the powers of the government. Now, coming to this side, when we say parliamentary supremacy, it is one of the most important features of the British Constitution, because in Great Britain there was no authority called the Constituent Assembly. There was no institution, and the Parliament took all the decisions itself. In our country, if you see, the Constitution provides for the Parliament. It is mentioned in the Constitution that the Parliament shall consist of the President, the Council of States, and House of the People. Not only this, how the members of the Parliament will be elected, means how the members of the Lok Sabha, Rajya Sabha will be elected, what will be their powers, how the bills will be passed, what will be the privileges and immunities of the MPs. Everything has been mentioned in the Constitution. But in United Kingdom, all the powers of the Parliament, they were decided by the Parliament itself. Not only with respect to the Parliament only, but other organs of the government, judiciary, executive, everything was decided by the Parliament, because no Constituent Assembly. So the Parliament, it became supreme. And when we talk about the supremacy of the British Parliament, it can make laws on any subject, and it can change an existing law by a very simple process. This is, we can say, the parliamentary supremacy. Here you can write as note, N-O-T-E. This question was asked in the last main examination also. Comparison of the sovereignty of the Indian Parliament with the British Parliament. Such type of questions will be there. So in India, there is supremacy of the Constitution, but in Great Britain, there is supremacy of the Parliament. So here you can write as note, the supremacy of the Parliament, as it exists in, as it exists in the UK refers to the supreme law-making power, of the British Parliament, supreme law-making power of the British Parliament. Full stop. The British Parliament can change any existing law, by a very simple process. Full stop. It can make laws on any subject. And the laws made by the parliament and the laws made by the parliament cannot be challenged before any authority cannot be challenged before any authority and cannot be declared as null and void. Null, N-U-L-L, null and void means invalid. Full stop. According to some scholars, who have analyzed the British Parliament, comma, the British Parliament is so powerful, that it can make laws on any subject, except on changing a man into a woman and a woman into a man, except on changing a man into a woman and a woman into a man. Full stop. In other words, the British Parliament can make laws on any subject, which is naturally possible. So, if obviously तो last year आ चुका है, तो ये नहीं कि obviously every year this question will be asked, but when we talk about the Indian constitutions or Indian parliament, in a structure, the Indian parliament may have drawn its inspiration from the British Parliament. The crown is the part of the British Parliament. In our country, the president is the part of the parliament. They have got two houses, we have also got two houses. But if we talk about the powers with respect to sovereignty, our parliament is not sovereign as the British Parliament. In our country, the parliament is bound by the provisions of the constitution. It will have to make laws on the subjects for which it has been authorized by the parliament. And not only this, it has to make laws not in accordance with the constitution, but it will have to follow the process which has been mentioned in the constitution. That is another thing, because how the laws will be made, how the constitution will be amended, everything has been mentioned in the constitution. That has to be followed by the parliament. And not only this, one more aspect has been added in the context of India by the judiciary, that is, it should not go against the basic spirit of the constitution, that is known as the basic structure. So, the Indian Parliament is not so sovereign as that of the British Parliament. So if the comparison is asked, obviously you will have to write like this only. When I will be discussing the Parliament, I will again discuss sovereignty of the Indian Parliament with you. This was the first aspect. So we have a written constitution, and to develop a better understanding, we discussed unwritten constitution also. Now coming to the second or the next salient feature of the Indian Constitution. Yes. When we say enacted, a group of people sat down together and then within a specified time, 1 year, 2 years, whatever it is, they wrote the constitution and then they said, this is the constitution of this country. That is enacted constitution. Evolved constitution, no body was there which wrote the constitution. It was a gradual evolution. Laws were made from time to time and they became the part of the political system. That is gradual evolution. No body, we can say, it enacted or it wrote the constitution as such. In that context, we had written it. Now, coming to the next salient feature, India has a parliamentary system. Now, going by the syllabus of the preliminary examination, the syllabus says political system. So, we will have to discuss the parliamentary system as a political system. Now, across the globe, we have got in some countries parliamentary system, and in some of the countries we have presidential system. So we have to discuss the difference between these two. What is the basis? You can write it. Based on the relationship between the executive and the legislature in a state the political systems have been classified as parliamentary and presidential. So what is the basis of this classification? In a particular country, what is the relationship between the executive and the legislature? So based on that, the political systems have been classified as parliamentary and presidential. So in a particular country, what is the relationship between executive and the legislature? Now one by one we will be discussing it. First of all, Coming to the parliamentary system. Parliamentary system does not mean that there will be a parliament or there will be a legislature. In every country which is democratic, we have got a legislature. Parliamentary system, in a parliamentary system, there are two heads. Head of the state and head of the government. The head of the state is the nominal head. And head of the government is the real head. For example, in the United Kingdom, the crown is the head of the state. Crown can be king or the queen. And the prime minister is the head of the government. In case of India, the head of the state is the president and the head of the government is the prime minister, who is the real head. Now, there can be a question in your mind that, sir, when the prime minister is the real head, why not prime ministerial system? Why it is termed as parliamentary system? Here, the prime minister, who is the real head, he belongs to the parliament. He must be a member of the parliament. So the parliament provides for the head of the government. In United Kingdom, the British Prime Minister, he must be a member of House of Commons. In our country, whether you are a member of the Lok Sabha or the Rajya Sabha, you will be termed as an MP, member of parliament. In bracket it is written Lok Sabha and Rajya Sabha. But basically, if you talk about United Kingdom, the members of the House of Commons, they are known as MPs. They are known as MPs. And the members of the House of Lords, they are termed as Lords. Before their name, we can say Lord will be there. It means they are the members of the House of Lords. So, then you will say, sir, in the different parts of the world, the legislature has got different names. So, why parliament again? Because such a system evolved in the United Kingdom. And the United Kingdom or Great Britain is termed as the mother of parliamentary democracy. And in Great Britain, the legislature is known as the parliament. So from there the nomenclature came, parliamentary system. Now, so this is the first important classic, we can say, aspect, that the head of the government is the real head. The second point you can write, a member of the executive that is a minister must be a member of the legislature. Must be a member of the legislature. You see, all our ministers, they are either the members of the Lok Sabha or the Rajya Sabha. Even at the state level, you see your ministers, they are either the members of the Legislative Council, and wherever we have a bicameral legislature, they can be the members of the council also, assembly or the council. So a minister must be a member of the legislature. No doubt, in our country there is a law that even a non-member can be a minister for 6 months. A non-member can be a minister for 6 months. But within 6 months, the person will have to get elected in the either in the Lok Sabha or in the Rajya Sabha. Then thirdly, the executive is responsible to the legislature especially the lower house is the popular house. First aspect, second aspect, and third aspect. UPSC is very fond of asking questions on parliamentary system. And these 3 points that I have highlighted, not a single statement will be asked from outside it. These are the 3 aspects of the parliamentary system. इतना पढ़ के चले जाओगे, UPSC every alternative year it asks questions. Which of the following is a feature of a parliamentary system? Which of the following is not a feature of the parliamentary system? Which of the following are the features of the parliamentary system? 1 and 2, 2 and 3, 3 and 4. Such questions will be there. And these 3, अगर इतना पढ़ के गए, आपका काम हो गया. So you need to be very much focused from the examination point of view. If you have not understood it, I will try to make you understand with the help of an illustration. एक और मैं आपको अटेम्प्ट करता हूं to get you to develop an understanding in you if you have not understood it. Electorate. Electorate means the voters. Those whose name is there in the voters list, they are the electorate. All of you are voters or not? How many of you are not the voters? So all of you are voters. Good. So all of you are electorate. Now what we do in the elections? In the election, the electorate, it elects the legislature. It elects the legislature. So the electorate, we do not elect our ministers. Suppose in this Lok Sabha elections, if you are there in your constituency, you may have given the vote. So for whom you have given the vote? To elect your representative. To elect your representative. You had not given the vote that he will be our minister, but you in your mind, okay, he will be our representative. So the electorate elects the legislature, and the political party which gets majority in the lower house, that is the popular house, जो अभी इलेक्शंस हो रहे हैं लोकसभा के, so the members of that political party which gets the majority here, they becomes the members of the executive. They becomes the member of the executive. So this is the point that we had written, that the members of the executive, they must be the members of the legislature. So the vice versa will not be correct. All the members of the legislature, they are not the members of the executive, but all the members of the executive, they must be the members of the legislature. You see, our prime minister, he must be a member either of the Lok Sabha or the Rajya Sabha. Then you see all our ministers, they are either the members of the Lok Sabha or the Rajya Sabha. At the state level also you see, our ministers, they are either the members of the Legislative Assembly, and in case of bicameral legislature, either of the Assembly or of the Council. There is a fusion here. That is what we had written here. Based on the relationship between the executive and the legislature, we have got parliamentary and presidential system. So there is a fusion. A member of the executive, that is we are talking about political executive, the ministers must be the members of the legislature. And the third point we had written, the executive is responsible to the legislature especially the lower house. Means so long as you have got the majority here, you will be there in power. That is what we have written here. So responsible to the legislature, especially the lower house. Means if a no confidence motion is passed, means if the house will pass a no confidence motion, means it will, the party has no majority, the government will no longer be there. So the survival or the existence of the government depends on the legislature. If the legislature will pass a resolution, then your government will no longer be there. This was your parliamentary system. Now coming to, so this is the system that we have in India, in United Kingdom. We have taken this concept of parliamentary system from United Kingdom. Now coming to presidential system. In a presidential system, the head of the state and government is the same. Is same. The US president, he is the head of the state and he is the head of the government. As the head of the state, he is the signing authority everywhere and he takes all the executive decisions, not all the legislative decisions, he takes all the executive decisions. In our country, who takes the real decisions? The Council of Ministers headed by the Prime Minister, and the president is the signing authority as the head of the state. Then, so this is the first point. Second point you can write here. A member of the executive cannot be a member of the legislature cannot be a member of the legislature. So, if a minister is there in United States of America, the ministers are known as secretaries in the US. They must not be the members of either the Senate or the House of Representatives. If a member of the Senate or a House of Representatives, that is the US Congress, is appointed as the secretary, means as a minister, he must resign and then only he can take oath as secretary. For example, you may have heard the name of Hillary Clinton. थोड़ी पुरानी स्टोरी है, but you may have heard about Hillary Clinton. Hillary Clinton was the Secretary of State when Obama had become the President of America for the first term. He was the American president for 2 terms before Trump. So he was there before Trump. Then when he became the President of America for the first term, he had appointed Hillary Clinton. Hillary Clinton was the wife of Bill Clinton. He was also one of the American presidents. But when she was appointed the Secretary of State, she was a senator. She was the member of Senate. She resigned from the Senate and then only she took oath as the Secretary of State. You cannot be a minister as well as a member of the US Congress at the same point of time. There has to be clear-cut separation. Members of the legislature and members of the executive. Then here I'll tell you with the help of an illustration. देखो, US is a role model of a presidential system. The US case. In the US, the electorate it elects the members of the legislature. It elects the members of the legislature. And in separate election, the US president is elected. The US president is elected for 4 years term, and the legislature, that is the US Congress, it has got 2 houses, the Senate and House of Representatives. The people elect the members of the Senate every 6 years. There is direct election also. No doubt it is just like our Rajya Sabha. But in case of Rajya Sabha in our country, the MLAs elect the representatives. But here the people directly elected the representatives. and House of Representative is our Lok Sabha, is just like our Lok Sabha. The term of our Lok Sabha is 5 years. The term of House of Representatives is 2 years. So every 2 years, the people of America, they elect their representatives to the House of Representatives. Just as we elect our representative in the Lok Sabha every 5 years, and every 6 years, the senators are elected. They are also directly elected by the people. In case of India, what we had discussed, the party which gets majority in the legislature, that is especially the lower house, will be forming the government. But here in case of America, it is not there. Separate election for the president, and any change here, it hardly matters. It will not have an effect on the term of the president. Even if his party members will be less in Senate or in House of Representatives, it hardly matters. In India, if you don't have a majority in the Lok Sabha, your government will no longer be there. But here, it is not the case. He is elected every 4 years. And after the American president is elected, he appoints a person of his choice as he appoints the persons of his choice as secretaries of his choice. They can be political persons, they can be non-political persons also. Anyone can be appointed as secretary, and the secretaries must not be the members of the legislature. They will not take part in the proceedings of the legislature. This is, we can say, the presidential system. So, in presidential system, what we see is that there is strict separation of powers. The executive functions will be discharged by the American president and his group, that is the secretaries. The president and his team has nothing to do with the system of the legislature. The bills will be introduced by the members themselves, that is the House of Representatives and the Senate. The bills will be passed by both the houses, and then it will be presented to the president for his assent, as the head of the state. So, the ministers cannot initiate a bill. They will not be taking part in the proceedings as the ministers in our country, they do. So, here another important thing that we need to understand is the concept of separation of powers. Doctrine of separation of powers. See, there is difference between division of powers and separation of powers. People get confused. When we say division of powers, it is the central government and the state government. In that context, we use this term division of powers. When we use the concept of separation of powers, it is in a different context. You see, every state has got 3 functions to perform, as we had discussed in the last class. Law making, law implementation, and law adjudication. During monarchy, what used to happen? All the 3 functions were vested in the king. The king was the sole lawgiver. He was the sole implementer of the law, and he was the sole judge. It was dictatorship. A single person discharging all the functions of the state. But in democracy, these 3 functions of the states they have to be performed by three different organs. This is the concept of separation of powers. You may note it. The doctrine of separation of powers was propounded by the French philosopher Montesquieu. Full stop. He was of the view that if the three functions of the state that is lawmaking, law implementation, and law adjudication is vested in a single person, or a single institution, comma, it may lead to dictatorship. Full stop. In democracy, these three powers or these three functions of the state are to be vested in three different organs. Full stop. That is the concept of separation of powers. कभी भी ना confused नहीं होना, because I have seen people arguing among themselves. No, division of powers and separation of powers are the same. नहीं. Social sciences में there is difference between text and context. I always tell this aspect to my students that if you are a student of social science, then the context will be more important. ऐसे भी if you will be reading the subjects like political science, sociology, or any of the humanities subject, the contextual approach is more important. आप देखोगे, how many of you have done your graduation from Delhi University? आपने कहां से पढ़ा बेटा? सत्यवती कॉलेज से पढ़ा. ठीक. कौन सा सब्जेक्ट पढ़ा? पॉलिटिकल साइंस पढ़ा. रीडिंग गांधी था क्या आपके टॉपिक में फर्स्ट ईयर में? आपने क्या कोर्स पढ़ा है? बीए ऑनर्स पढ़ा है. अच्छा, ठीक. एक आपका यहाँ कंपलसरी पेपर होता है रीडिंग गांधी, या ऑप्शनल पेपर फर्स्ट ईयर में पढ़ाते? नहीं पढ़ा. अच्छा, ठीक. सो बेसिकली व्हेन वी आई जस्ट आस्क आउट, आपने कितने लोगों ने पढ़ा है और पॉलिटिकल साइंस कॉलेज में? आपने ही पढ़ा है. अच्छा, आपने ही पढ़ा है. आपने कहां से पढ़ा बेटा? इग्नू से पढ़ा. ठीक. आपने कहां से पढ़ा बेटा? ओपन. आपने पटना यूनिवर्सिटी से. किस कॉलेज से? मतलब बहुत सारे कॉलेजेस हैं. मेन कैंपस में, अच्छा ठीक। तो हाउ मेनी ऑफ यू हैव रेड सोशियोलॉजी? देखो, when you read subjects like political science or social sciences, context is very important. For example, Gandhi gave this concept in what context? In what context? So context has to be, is more important. Plato, he gave the concept of philosopher ruler. In which context he gave the concept? As a philosopher pagal ki tarah concept de diya. But if you understand the concept, that is in what context the philosopher has given this view, you will be able to appreciate the things. That is why I was talking to you with respect to division of powers and separation of powers. Wherever there is separation of powers, then separation of powers means the separation between the three functions of the state: law making, law implementation, and law adjudication. They have to be performed by three different, and division of powers means union government and the state governments. Now, in India, we have a parliamentary system. So, a strict separation of powers may not be feasible between the legislature and the executive. Why? You will see that while making a law, who takes the initiative? Council of Ministers. We will be making laws like this. Then the draft of the bill, it is prepared by the ministry. It is prepared by the ministry. And then who presents the bill? The ministers. Generally, the private members can also present the bill. But generally it is the ministers. And then ministers, they take part in the proceedings also as the member of legislature, and they take part in the discussion, debate on the bill as the member of the legislature. And after the bill is passed, they are responsible for the implementation also. They look into the implementation part also as a member of the executive. There is a fusion. So strict separation of powers may not be feasible in a parliamentary system. So you can write it here in the next paragraph. As India is having a parliamentary form of government, as India is having a parliamentary form of government, a strict separation of powers may not be feasible between the legislature and the executive. Between the legislature and the executive. Full stop. But Article 50 provides for separation of judiciary from the executive. Separation of judiciary from the executive. So the executive will not try to influence the judiciary. The judiciary will also not interfere under we can say normal circumstances. So in our country also there is concept of separation of powers to some extent. Jaise no discussion can take place in the houses of the parliament on the conduct of a judge of the Supreme Court or a High Court except on a motion for the removal of the judge. Under normal circumstances, the legislators cannot discuss on the conduct of the judge of the Supreme Court or the High Court. And not only this, a member of the parliament or of a state legislature is immune from any action in a court of law for whatever he has said or whatever he has revealed or for whatever vote he has casted inside the houses of the legislature. The judiciary is not going to ask him that, hey, why you have spoken like this? He can be punished in accordance with the rules and procedures of the house by the presiding officer, but not by the judiciary. So, there is separation of powers to some extent. There is, and Article 50 provides for that. Underline कर लेना Article 50. यूपीएससी में ये सब पूछते हैं. Separation of judiciary from the executive. Article 50. In the next sentence, we can write the doctrine of SOP, separation of powers, is strictly enforced in a presidential system like the US, where the three organs of the government discharge their respective functions. So the bills will be initiated by the members of the legislature. No doubt, indirectly the president can influence through his member. बोले कि चलो ठीक है, you introduce such a bill. That is a different thing. But the ministers will not be there inside the houses of the legislature to defend the bill. And the judiciary is also free. Now, this is also dangerous, separation of powers. Because if unlimited power is given to the executive with respect to appointments and other executive decisions, then the executive can indulge in nepotism, corruption. So it can also go here and there. Then if the legislature is given unlimited power to make laws, then it can also make laws which may not be beneficial for the larger interest of the society, but it may cater to the interest of only a certain sections of the society. It can be possible. The influential people will have say in the legislative process, and then in the absence of proper checks, even the judiciary can go here and there. Because the members of the judiciary, that is the judges, they are the product of this society only. They also have got instincts. They can also indulge in corruption. So, absolute separation of powers is not desirable, it is not good also. That is why the doctrine of separation of powers has to be accompanied with by the doctrine of checks and balance. What is this doctrine of checks and balance and how it operates? That we will be taking up for discussion in tomorrow's class. कि how this system operates in America, India का तो हम लोग और भी पढ़ेंगे, so that if wherever it is required, you can make a comparison to it. So we'll stop here for the day. I'll see you tomorrow.